Okay, ladies and gentlemen, gentlemen and ladies, ladies and gents, a young man named Corey sent me something last night or this morning, and I decided to take a look. Normally I would not because too many things going on, but when he sent it to me, implied waiver of the right to arbitrate. Ladies and gentlemen, did you know that if you participate in a court proceeding that deals with the same issue of your arbitration, that it can be perceived that you have waived your right to arbitration? But not according to our contract. Our contract has arbitration being binding upon all parties, which means that they have waived their right to waive their right. Again, when they bring up that's why you put in your motion to compel arbitration. Why? Because, see, this case was brought before the Supreme Court because you had two parties, the Stock and Associates versus Citibank. And it doesn't matter what the issue was. Citibank was suing them, and they brought a claim against Citibank, so they appealed and asked for certiorari before the United States Supreme Court. United States Supreme Court elected to hear the case, but before the case could be arbitrated by the Supreme Court, the parties settled. So the Supreme Court never heard this. So what they did is they relied upon the other circuit courts for their opinion. Okay, notice the contract governing relationship between Stock and Citibank included an arbitration provision that provided, in relevant part, either Citibank or Stock may elect to require any dispute between them concerning the aforementioned accounts or any other bank deposit accounts in line with credit be resolved by binding arbitration. You see, it says they may elect. Ours doesn't allow for such an election. Ours say that any dispute regarding the matter will be handled through binding arbitration. However, notice this: on February 23, 2009, Citibank sent Stock a letter saying, election, arbitration. Stock rejected Citibank's election. So Citibank filed a motion to compel arbitration the following day. Initially, in the state court, when it became apparent that under Florida state law, Citibank had waived this right to arbitrate when filing an answer without expressly reserving the right to elect to arbitrate. See, when we filed an answer in our case, there was no arbitration agreement at the time. But now that the agreement has been solidified by the parties, now we're letting them know, hey, arbitration. But anyway, Citibank withdrew its motion to compel. Instead, Citibank filed a petition to compel arbitration in the United States District Court for the Southern District of Florida. In May 2010, the District Court denied Citibank's petition, holding that Citibank had waived its right to arbitrate. As part of its determination, the District Court found that Stock had suffered prejudice due to Citibank's delay in demanding arbitration. It's a good thing we've been demanding arbitration from the very beginning. Every motion, every hearing, every court date, everything, because that's what you have to do. You see, you have to demand arbitration. You have to keep relying on the contract. You have to act as if the contract is 100% binding on all parties. And why do you do that? Because if you don't, they will perceive it as you did not believe the contract was legitimate, because if you had, you would have pursued it and blah, blah, blah. This is what the 11th Circuit has said. It said, first, we decide under the totality of circumstances the party had acted inconsistently with the arbitration right. So you can't be inconsistent. You can't be relying on arbitration and trying to defend yourself and litigate a case. Okay, so I told the court, I'm exercising my Fifth Amendment right, because they'll use it as evidence against you if you participate in the case. So you exercise your Fifth Amendment right to remain silent and tell them that if they can move forward, move forward. If the law permits it, and if the contract permits it, move on forward. Go on now. Second, we take into consideration whether or not to do so would prejudice the other party. Ladies and gentlemen, they couldn't consider the second factor. They can only consider the first factor. Now, the first thing I did is I looked up that case. The S&H contractors, this was also 11th Circuit Court. See, 11th Circuit, I only know that I didn't even look at that. I just put it in and went here. As you can see, it says S&H. Hey, is that the sugar cane? No, that's G&H. Pure cane sugar, that's the one. That's G&H, y'all. I remember because I was a kid at one point. Okay, appeal the judgment, 2 separate cases, the district court, blah, blah, blah. Don't care about none of that. That's not anything that's of a concern to us. You know, I like this song. This is Mary J. Blige. Mary J., who are you singing this song with? Sting. Ladies and gentlemen, I like this song. There's just something about this song that is just, I like the song. All right, Alabama Corporation entered into a contract and a Delaware corporation with its principal place of business in Wisconsin for the purchase of a disassembled walking drag line. What the? It's a walking drag line. Well, it's an excavation machine used for digging coal. Okay, so they bought this used machine, disassembled, and they were supposed to assemble it. But of course, you know, when you buy something used, somebody always leaves something out. Okay, after entering into the contract for the purchase of the drag line, Taft decided to hire a contractor to assemble the drag line and entered into negotiation with S&H, a Kentucky corporation with its primary place of business in Kentucky. The negotiations culminated with the contract signed on December 6, 1984, under which S&H agreed to assemble the drag line under the supervision of these engineers. At the time of the contract's formation, S&H had not been qualified by the Alabama Secretary of State to do business in Alabama. In fact, S&H had not qualified to do business in Alabama until 1986. In March 12, 1986, S&H filed a complaint in the United States District Court for the Southern District of Alabama, alleging in errata that it had substantially performed its responsibilities under contract and that Taft had breached the contract by failing to pay the amount due for the substantial performance. In other words, one person is saying we did it and they didn't do it, and there's a conflict. However, on February 3rd, 1987, Taft filed a suit in the Northern District of Alabama enjoining arbitration proceedings, arguing that the court had declared the entire contract void in its order dismissing S&H suit on the contract. On April 17, 1987, the court granted Taft prayer for relief and enjoined arbitration proceedings in Alabama. The court reasoned that if the arbitration proceedings were conducted in Alabama, the federal district court in Alabama might be required to enforce the arbitration award and, in effect, the enforcement of the underlying contract. In the court's view, such a result would undermine the Alabama policy, public policy, as expressed in its form, closing laws. The Arbitration Act is what they're referring to. S&H then petitioned the American Arbitration Association to transfer the arbitration proceedings to Atlanta. The association granted the petition, and on March 29, 1988, Taft filed a complaint in the United States District Court for the Northern District of Georgia, requesting that the court enjoin the arbitration proceedings. Taft argued that the proceedings should be enjoined for 2 reasons. First, that according to Taft, the contract with S&H is void for all purposes, and S&H could not demand arbitration under a void contract. Now see, ladies and gentlemen, for quite some time, you've seen the word enjoined in here, and I did a video telling people that I know the word enjoined. I know exactly what enjoined means, and when we looked up the legal definition, it did not equal the same definition here. Enjoining them is an injunction against them, preventing them from going forward. Well, anyway, S&H could not demand arbitration under a void contract. Second, Taft argued that in bringing suit on the contract in the federal district court before demanding arbitration, S&H waived its right to demand arbitration. Taft moved for summary judgment. The district court granted the motion and enjoined the arbitration proceedings, said you guys can't go to arbitration because you waived your rights by filing a lawsuit. That's right, they did. But then by filing a lawsuit, they're in breach of contract. So even a lawsuit has to be dismissed. The court held that the contract was both unenforceable and void, thus the parties never agreed to submit to arbitration. The court declined to address the waiver issue. S&H again appealed, and that appeal was consolidated with S&H earlier appeal from the district court dismissing the contract action. We address each appeal in order. Okay, I don't care much about this, ladies and gentlemen. Our contract explicitly says that the court proceedings are the ones that are void. You must remember, all of the court proceedings are administrative only. Arbitration is an alternative administrative remedy, meaning we don't have to use the court. We can utilize arbitration as our sole means. If they go to court, they're in breach of contract, which is what we say from day one. If they go to court, they're in breach of contract. We've been highlighting they've been in breach of the contract from day one. Every time they put something into the court, challenging something they've already agreed in the contract to not do so. Okay, ladies and gentlemen, I got things I need to do. I wish I could spend more time talking to you guys about this, but the fact is I just wanted to let you know that if you are arbitrating, you can't file a lawsuit because you will be waiving your right to arbitrate. Sorry, it's just the way it is. If you have a lawsuit filed against you, you must notify the court that the parties have agreed to binding arbitration. And you are scheduling arbitration at this time with the arbitration association of your choice as the contract permits. Or you don't even have to say the arbitration association of my choice. You say what the arbitration association is agreed upon by the parties. Just that simple. The courts have no jurisdiction. They can deny your motion to compel. They can say, I'm denying this and denying that. You have an automatic right to appeal. Especially those of you who have criminal so-called proceedings. Your appeal is criminal, which means there are no filing fees. Just got to know what you're doing, people. Just got to know. Yeah, I know they're going to hate me, but I don't care. My job is to make sure they recognize my existence so that they understand. Ladies and gentlemen, with that being said, we're going to let y'all get back to y'all's lives. Figure out how y'all going to do 1, 2s, 3s, 4s, A, B, C's, northwest, east, west, southwest, and all the other longitude and latitudes in your life. And while you're figuring that out, the rest of us are going to go ahead and have a Coke and a smile. So, goodbye.